context-related piece that I wanted to mention is that, as Tom has rightly alluded to, there are two big buckets of frozen Russian assets, the public and private assets. We don't have the complete certainty as to the amounts involved, and Martin Sandbo of the Financial Times wrote an excellent short piece in early January looking at some of the figures that governments have put out there in terms of the assets they have frozen. And as he mentioned, some of the discrepancies in those figures are extraordinary. So, for example, we're not quite sure whether we're talking about 350 billion or 300 billion in frozen assets. Well, that's a difference of 50 billion. That's the entire EU sanctions, the EU assistance package to Ukraine. So the issues that we're talking about here could not be more monumental in terms of the amounts involved. But the important bit is that the public assets dwarf the amount of private assets frozen. So you see that on your screen. We're talking about approximately 300 to 350 billion in central bank reserves versus approximately 60 billion in private property. When the freezing took place, literally in a matter of days after the invasion, the full-scale invasion of Ukraine, a lot of the initial policy discussion was focused on the private assets part of the question. There were proposals floating around in the US and also in the EU as to what can be done in connection with the private assets. So how do we take away the property of oligarchs? How do we sell yachts to fund Ukraine's war effort, and so on? I think that a lot of that discussion mistook some of the sensible but modest changes to proceeds of crime laws, which might well be worthwhile, with the broader question of, is it feasible to use this to assist Ukraine? The answer to that latter question is no, because the amounts pale into insignificance compared to the scale of the damage. So when we're talking about real meaningful assistance to Ukraine as the primary objective of the freeze to cease debate, inevitably we are going to be interested in public assets. And this is where the discussion has perhaps unsurprisingly drifted towards over the last year or so, as proposals have started to emerge in that context. And of course, we could not have been more, I suppose, fortunate with the timing for this event, with the news yesterday that the Senate Foreign Relations Committee in the US gave green light to a bill that would enable the confiscation of frozen central bank reserves in the US. And that's just one part of the broader conversation that has been happening across countries. So what are the key issues that arise there? I think the first obvious question is, okay, is there a domestic legal framework to enable the confiscation of frozen assets? The answer is inevitably no. People don't normally do that. Assets are frozen. You don't normally confiscate them and hand them over to another country. But that, I think, is perhaps the less interesting question, because as the US discussions demonstrate, domestic laws can be amended. That's what parliaments and legislatures are there for. The question, therefore, is, are there some limits as to what they can do in amending their legislation? And the two main sources of those limits would be international law. So the rules of international law that can't be changed by states unilaterally. And I think there's consensus among both the proponents of seizure and the opponents of that idea that whatever happens needs to happen within the parameters of international law. There's no suggestion that the UK or the US or any other country breach international law and transfer assets to Ukraine. The other important source of constraints is domestic constitutional guarantees. So is it, for example, possible that in some of the countries concerned, the right to property under domestic constitutional law would erect a barrier in the way of confiscating the property of another country's central bank? The answers to that, I think, depend across jurisdictions. I'm not going to try and go into that territory, but there's been some debate, for example, as to what is feasible in the United States and whether the due process guarantees under the US Constitution accrue to agencies of foreign governments. Those are the sorts of discussions that I think are also important and will happen or are happening if states seriously contemplate those measures. But I think that the biggest block of issues that the attention has been focused on so far pertains to international law. And there are three categories of those issues. Sovereign immunities. Obviously, we're talking about central bank assets. Surely they're immune. Well, everyone agrees that central bank assets enjoy immunity. but there's not necessarily the same degree of agreement as to what that immunity means, and also, more importantly, how that immunity interacts with the law of countermeasures, which is another part of international law that directly bears on what can be done to Russian assets. So these are the two parts of the overall international law landscape that I'm going to be focusing on. There are a couple of other issues that I would have normally touched on for the sake of completeness, but I'm going to forgo them in the interests of brevity. One of those is investment protection, so we can touch on that in the Q&A if we want to. And then there are also some questions around the concept of collective self-defense, which does not mean that you're at war with Russia. Other states could engage in collective self-defense alongside Ukraine without being a co-belligerent. And collective self-defense does not necessarily need to be forcible. So you could have non-military measures of self-defense, a bit like the idea of countermeasures. But in the current policy debate, the two key points have been sovereign immunities and countermeasures. So I'm going to outline the state of the discussion in those areas. First, let's start with sovereign immunities. If we did a survey of the domestic laws of various countries, and in fact, some scholars like Ingrid Brunk, whose quote you see on the screen, have done exactly such an analysis, you would see that domestic laws invariably afford immunity to central bank assets. And that's immunity from execution. So you can't attach them, you can't freeze them in connection with a court proceeding, and you can't confiscate them in the enforcement of a court judgment. But on the other hand, central bank assets have traditionally been in the crosshairs of various parties who have claims against states. And traditionally, that would be sovereign default litigation. So you have a claim against a state, you know the state is not going to pay, but it's got foreign currency reserves in other countries. So you go to those other countries and say, well, can I not enforce my claim against the reserves? Generally speaking, that's not possible. But the quote from Ingrid Brunk highlights that tension. On the one hand, you have immunity. On the other hand, it's a really attractive source for anyone who has a claim against the state. So if sovereign property, especially central bank assets, are immune from execution, why do we still have that discussion? Is that not the end of our consideration of this matter? Well, the answer is no. And this is where we get into some of the more complicated matters of international law. The international law of sovereign immunities, as many of you here will know better than I do, is part of customary international law. So it's not completely codified. It's developed organically as a result of state practice and opinio juris. We have some indications of what customary international law requires, but we don't have a complete codification, and there is some uncertainty around the edges. If we look at the sources that are traditionally thought of as authoritative and giving us a good indication of what customary international law requires, all of them have one thing in common. All of them establish the immunity of central bank assets, but they also speak of that immunity in the context of court proceedings. So you see this on your screens. You see the wording from the UN Convention on State Immunity, the European Convention on State Immunity, and this kind of wording goes all the way back to some of the first attempts to codify the law of sovereign immunities in the 1930s. For example, Harvard University's codification project in 1932. So what does that mean? Well, one approach to this is to say, okay, so immunity is limited to court proceedings. Now, what are we talking about with proposals like the Repo Act in the United States? We're not talking about any court proceedings. A legislature, for example, Congress, would pass legislation that would explicitly authorize the government of that country to take frozen Russian assets and give them to Ukraine. There's no court proceeding involved in that. Do sovereign immunities apply or not? Now, at first sight, that might look like a slightly wacky question. Of course they would apply. Courts are normally associated with greater levels of due process, with greater rigor. So if the courts of a state can't do something, why would we say that governments can do that without the involvement of courts? It just doesn't make sense. Now, one answer to that, an answer that is eloquently represented by scholars such as Tom Roos, Ingrid Brunk, to a lesser extent, Philippa Webb, to a lesser extent in that I think she's a bit more tentative in her conclusions, but not less eloquent, is that the key is in the history of international law. We just look at how those rules emerged. And here's a nice quote from Tom Roos that speaks to that. And I'm just going to read out that quote because I think it's an interesting one. Of course, this creates something of a paradox, this approach to sovereign immunities. It places certain persons and property in the absurdly paradoxical position of being inviolable and immune from judicial measures, but at the mercy of administrative or executive actions. Yet international law is no stranger to paradoxes. In the end, it must be recalled that the rules pertaining to the immunity of states and state officials were created primarily to avoid the courts of one state to sit in judgment of another state, and to prevent private persons from litigating against foreign states before domestic courts. So it's this sort of, historical, history-oriented account of sovereign immunities. But there are other accounts too. So other commentators would say, hang on a moment, let's look at the rationale of sovereign immunity rules. The rationale is to ensure that one state doesn't exercise sovereign power over another state. If that's true, does it really matter whether that power is exercised by a court, the government, the legislature? Just doesn't make any difference. And here's an example of a quote by Jean-Marc Thévenin, a leading international lawyer who represents that broader approach to sovereign immunities and says, look, it's all about sovereign equality. It doesn't really matter whether the measure is originating within the courts or within the government or legislature. It just doesn't matter. There's no reason why that would be important. So we've got those sort of battle lines that have been drawn. We've got those two conflicting accounts of sovereign immunities, and we don't have any state practice to definitively resolve that contradiction. I think, we might as well flip a coin. It's impossible to say with certainty one view is right and the other one is not. It's just two conflicting interpretations of what we make of those statements of customary international law in the international conventions and other sources that we have. To make things a bit more complicated, there's another notion that features in this discussion, and that is the notion of inviolability. So let's think about diplomatic premises. Can anyone ever seize the diplomatic premises of another state? Well, the answer is no. And it doesn't matter whether the source of that measure is judicial action, a law passed by a state, the actions of a government, doesn't matter. And that's because diplomatic premises are inviolable. So that's a different concept under international law that encompasses the prohibition of any interferences with the property that is inviolable. And that notion featured in litigation before the International Court of Justice that was ultimately abandoned, but is an interesting case that often features in these discussions of the concept of inviolability. And that's the case between Timor-Leste and Australia. The Australian police seized certain documents from the offices of a Canberra-based lawyer for Timor-Leste. Timor-Leste said, hang on a moment, these documents are our property. We're a sovereign state. These documents are immune. And Australia said, no. What you really mean is you're trying to claim that they're inviolable, because that's the status that would entail the prohibition of any interference with that property. Now, we know there are some things that are inviolable under international law. Diplomatic premises. There is no general rule of inviolability of state property. So your claim of immunity is misplaced because what you're really talking about is inviolability and you haven't established inviolability. Now, the case, as I say, was abandoned. So the ICJ never delved into those matters. But if we accept that understanding of the division between immunities and inviolability, the question is, well, can central bank assets maybe enjoy inviolability? After all, we've got all this body of domestic legislation that is pretty categorical in terms of the protections that it affords to central bank assets specifically, as opposed to even other categories of sovereign property. The answer to that is that's probably a bit of a stretch. We don't see any authority to the effect that central bank assets would be inviolable, but that's just another point to bear in mind. And so there's quite a lot of stuff to unpack there. It's like layers of an onion. You sort of peel away and away at different issues. But where we end up is no one argues, no one would dispute the fact that central bank assets benefit from immunity, but it's unclear where that immunity ends. Now, I think if you were in charge of confiscating $350 billion and you had to make the decision as to whether or not that is lawful, and you had to make that decision based solely on the discussion that I've outlined in relation to where sovereign immunities end, that would probably be a very, very difficult call. But where the discussion has really been focused over the past year, rightly so, I think, is not just that question mark over sovereign immunities and their outer edges, but the issue of countermeasures. So let us assume, for argument's sake, and let us assume as a pretty conservative legal position that central bank assets do benefit from immunities that are opposable to legislative and government action. Let's just assume that, for argument's sake, as a kind of, over-inclusive rather than under-inclusive approach to sovereign immunities. But of course, the reason why we have that conversation is not because G7 policymakers woke up one day and said, let's confiscate Russian assets. The reason is the damage that Ukraine is sustaining as we speak, and the violation by Russia of an obligation not to engage in a war of aggression, as well as a host of other concomitant violations of international law. Countermeasures are effectively a very commonsensical notion that if a state breaches its obligations under international law, then subject to certain conditions, other states can take action that would deviate from the observance of their international obligations. So you breach international law, we breach international law in response, but in a narrow, targeted and controlled way. Countermeasures cannot be punitive. They need to aim at restoring the state of compliance between the parties, and they need to be proportionate. So what are the key issues in the debate around countermeasures? First of all, I think it's worth saying that the US government, according to press reports, has circulated a paper among other G7 states arguing that third-party countermeasures, also known as collective countermeasures, would give the would provide the legal justification for the seizure of Russian central bank assets and the transfer to Ukraine. But there are two blocks of issues there. The first one is, can states other than Ukraine take countermeasures? And the second block of issues is, what are the other requirements around the lawfulness of countermeasures? And can those requirements be satisfied by the seizure of state assets? Let's look at the first question. So as those of you who've studied or practiced international law will know very well, the issue of third-party countermeasures has been controversial for decades. Much ink has been spilled over whether or not such countermeasures are allowed. Once again, battle lines have been drawn there. It's an issue that has been, metaphorically speaking, litigated extensively. But I think it's worth highlighting that there's been an ample body of commentary currently in the context of the Ukraine war, arguing that third-party countermeasures are permissible and would form a lawful basis for confiscating Russian central bank assets. And there have been a number of detailed studies that are of that view in general, not in the context of Ukraine, but in the context of the broader question of, are third-party countermeasures permissible? So I've listed here some of the sources of support for the lawfulness of third-party countermeasures in the context of the war in Ukraine. One of those is the sort of semi-public memo that was quoted and linked to in the Financial Times article that was signed by a number of leading international lawyers. But there have been also other reports, like the one lead authored by Lawrence Tribe, Emeritus Professor of Law at Harvard, Cambridge University's Tom Grant, and others. Now, there are still people who are of a different view, and I think Ingrid Brunk once again has pithily summarized that view, so it's worth quoting it here. Basically, what she's saying is central bank immunity is really important. It's a fundamental core tenet of how we live, of the international order. The doctrine of third-party countermeasures is a bit dodgy. So when you marry the two, a fundamental principle and a sort of slightly wobbly doctrine that remains contested, should you really base the confiscation of the property of another state based on that? So here's what she says. Central bank immunity from execution is a core principle of public international law about which there is no dissent. Third-party countermeasures, on the other hand, are generally contested and their legality is unclear in all circumstances. Now, if we want, in the Q&A session, I might come back to that argument and sort of talk about that in a bit more detail. But I think for now, it's sufficient to outline the kind of disagreement that exists there. And I think it's fair to say that the lawfulness or unlawfulness of third-party countermeasures is a subject on which a lot turns in our discussion of countermeasures. However, a lot of the public discussion of countermeasures and indeed expert conversation has focused not so much on third-party countermeasures, but on the idea that it's never permissible to confiscate the property of another state as a lawful countermeasure. And that, of course, has fundamental and profound implications beyond the Russia-Ukraine situation. There's a general question there of, can you confiscate the property of a state as a lawful countermeasure? Or is confiscation a measure that is never permissible? Now, what is the debate there? It all comes down to Article 49 of the Articles on Responsibility of States for International Wrongful Acts that lay out three requirements for the lawfulness of countermeasures. And I've sort of summarized them in square brackets, the inducement requirement. So countermeasures can be taken in order to induce a state to comply with its obligations. And the argument is, if you take a state's property and give it to another state in lieu of reparations, you're going beyond inducement. It's a kind of self-help. You take Russia's property, you give it to Ukraine. You're not inducing Russia to comply with its obligations. You go beyond that. The second requirement is temporariness. So countermeasures are limited to the non-performance for the time being of international obligations of the state taking the measures. Now, you confiscate property, well, that's not temporary. And then the third point is countermeasures shall, as far as possible, be taken in such a way as to permit the resumption of performance of the obligations in question. I think there are a couple of issues there that are worth mentioning. So first of all, let's remember that the articles summarize customary international law. They're not the source of law as such, but they are a generally good indicator of what customary international law requires. So is there any support in state practice for the idea that you can never confiscate the property of another state as a lawful countermeasure? The answer is no. Let's also remember that we're talking about financial assets here. We're talking about cash and securities. So when we think about issues such as temporariness and reversibility, it's worth remembering that we're not talking about, destroying the Mona Lisa or even destroying a bridge or whatever. We're talking about taking fungible liquid assets that can be repaid to the state from which they're taken. And now let's discuss a bit, and I'm mindful of the time, but I'm wrapping up over the next couple of minutes. Let's just discuss those requirements in the context of confiscating the property of another state. So let me give you a hypothetical example. So let's say that one state unlawfully expropriates the property of another state, and that property is worth $1 million. Let's say that the aggrieved state has 1 million in cash belonging to the state in breach in its territory, and it just takes that money by way of a sort of set-off. It says, well, you owe us 1 million, we can take 1 million from you, we're going to do that, that's a lawful countermeasure. On the restrictive interpretation of Article 49, that would not be a lawful countermeasure because it's not reversible and it's not temporary, and it's a measure of self-help and not inducement. But that's a difficult result to agree with, and there's no indication that states have ever supported such a counterintuitive understanding of a concept that's simply aimed at restoring the state of compliance between the parties. Countermeasures are there to ensure that states return to a state of compliance in their international relations. There are a couple of examples of states asserting their right to confiscate the property of another state when they're owed money. One example was in 1941, when Italian vessels were seized by the United States before the outbreak of formal war between the two parties, and Italy said, well, you've taken our property, we're going to take your property. The United Kingdom, for a long time, has grappled with the problem of what to do about the claims of British bondholders who were owed money by the Soviet Union after the Russian sovereign default as a result of the revolution in 1917. And on 2 occasions, the Foreign Office lawyers asserted that the UK does have the right to confiscate the money contained in the bank accounts of the Soviet Union in the UK. It never happened because of policy reasons and because the UK was cautious not to rock the boat in the context of the bilateral relations. But there was never an indication that that would be unlawful because it's a permanent and irreversible measure. In fact, what we can trace here is a very countermeasures-oriented thinking the states have reaffirmed rather than repudiated. What I think is happening in this discussion is that we're kind of conflating 2 distinct ideas. So we've got those requirements of temporariness and reversibility under Article 49, but we also have in our mind this sort of contrast between freezing and confiscation. So we're naturally primed to think freezing temporary, confiscation permanent, freezing reversible, confiscation irreversible. But that's not necessarily the case. You can confiscate financial assets and you can give them back. It's neither permanent nor irreversible in any real sense. And of course, that's been recognized in international law doctrine. So James Crawford, who was the ILC Special Rapporteur on State Responsibility, wrote in an academic article that damages of a financial character, for example, loss of profits or interest, is rarely irreversible. And the same approach was taken by the ICJ in the decisions on provisional measures in a couple of cases where the court said, look, if the only thing that can happen to you as a state is that you will lose money, well, that's not irreparable damage. There's no need for us to grant provisional measures, because if you succeed on the merits, you can be confiscated, you can be compensated financially. If you can repay, that's not, if your loss can be covered by repayment, if you can be compensated for your loss financially, that's not irreversible. So what I think the discussion boils down to, and this is genuinely the last point I want to make, I think a lot of the discussion boils down to a kind of quasi-legal argument, where people look at the proposals to move from freeze to seize and say, it looks dodgy. And it looks dodgy because it hasn't been done before. So something must be quite wrong with the proposals. Whether that's sovereign immunities, whether that's countermeasures, something's wrong. But what I think we need to recognize is that it takes an extraordinary set of factual circumstances for the freeze to seize debate to occur. So we need to have vast damages that make the debate worth having. We need to have a victim state that has not been extinguished. So if Russia had overrun Ukraine, we wouldn't have the freeze to seize debate. There'd be no country that would be asking for those funds. And then we also need to have a degree of political will on behalf of key international financial centers to even have that conversation. I mean, they're not talking about doing anything in their own interest. They're talking about taking someone's assets and giving those assets to another country. Why would they do that unless there's a clear moral imperative to act? And I think that, once again, taking the example of the British-Russian situation with the sovereign default, there's a lovely write-up of that in the American Journal of International Law, where the authors, Denz and Poulsen, trace the history of the discussions in Britain as to whether or not Britain should confiscate Russian state property. And the answer was no, Britain didn't do it, because there were different constituencies within the country. And some people said, well, we don't want to jeopardize the relations with the Soviet Union. And that's even in a case where Britain would be contemplating some confiscation for its own benefit rather than for the benefit of a third party. So I think we need to recognize just how extraordinary the discussion is and groundbreaking, not in terms of only the legal component, but also the practical component, which I think kind of sets the stage for that sort of quasi-legal argument as to why it hasn't been done before. So thanks for bearing with me as I went through all of that content. I hope that was helpful in setting the scene for some of the, I suppose, more practically informed views from Bart.
No, thank you very much. This was terrific, and a very, very nice comprehensive overview of all the different sides of the argument on indeed what is a complex set of legal, political, and economic questions. I don't have slides to present, but I'll just offer a few reflections on Anton's presentation and offer for you my perspective primarily on what is the state of play of the debate right now. As Erica kindly mentioned, I'm based in Brussels, so I've been tracking the thinking and discussions in Brussels in particular very, very closely over the past 14, 15 months. And indeed, people, as Anton has gone through it, have looked at these questions in great, great detail. There are no easy solutions, no sort of recipe books where you could go and find your clear-cut answer. And so, people have been wrestling with these issues, but it looks like there's at least now some momentum towards some consensus, some center of gravity, which I'll highlight at the end. I wanted to spend maybe just a couple of minutes on one issue which has been very much in the public debate over the past few weeks, a couple of months, at least if you're sort of focused on EU debates and Brussels center debates. But that is the issue of what to do with profits that have been generated on the underlying immobilized state assets. Anton addresses this issue very nicely in his paper. Didn't get a chance to cover it in the presentation, but let me just lay out the issue itself and then suggest where things seem to be ending up and why. So just to provide you brief factual context, something like 200 billion euro of Russia's state assets, the central bank reserves, have been immobilized at Euroclear, which is based in Brussels in Belgium. Euroclear is a financial intermediary, sort of a clearinghouse. It receives funds from one central bank or one depository and transfers them to another one. And shortly before the outbreak of the full-scale invasion in late February 2022, it appears that the Central Bank of Russia tried to move around its holdings from the United States, Canada, elsewhere, France, Germany, and it was moving them through Euroclear, and it got trapped there. So all of a sudden, 200 billion, something around then, of central banks' reserves are at Euroclear and have been immobilized since February of 2022. And since that time, there's been interest accumulating on these assets and profits accumulating. Last year, something on the order of 4 billion euro that has been generated by way of interest, high interest rates nowadays, as you all know. And so, take 200 billion, all you need is a 2% interest rate on that to generate 4 billion of income. And the question is, who does that income belong to? Now, this is an issue that was debated quite intensively among the various EU member states within the Council of the EU. Some viewed that the profits belonged to the underlying owner of the initial deposits, which is the Central Bank of Russia, and that even though the underlying state assets are immobilized, any profits should be immobilized and at least nominally attributable to the Central Bank of Russia. Others, including Belgium, held the view that no, that this is a question not as a matter of international law, but as a matter of national law. And under Belgian national law, where Euroclear resides, there's no automatic sort of default property right to some expected interest income of your underlying assets, that this is a question governed by contract law. And in normal times, in 2021 and so forth, the way Euroclear, as I understand, operates is that, it holds these assets very temporarily. It receives them and then transfers them. It's sort of a post office, a pipeline. And so the way it governs any interest that's generated, short-term interest that's generated off these assets, it might hold them for 24 hours, 48 hours, a little bit longer, is by contract, short-term contracts. And those will set out exactly what is the interest owed to the depository, to the original holder. And here, we have no contracts. because either those contracts had expired, since February of 2022, because they were short term, or they were superseded by sanctions. So in the end, in the absence of any contractual rights, the Central Bank of Russia does not have any inherent sort of property rights to an expected investment income of its immobilized assets. And so any investment income, any profits reverberate to Euroclear. It's a somewhat probably counterintuitive, maybe paradoxical situation. Interestingly, as recounted by an op-ed in Politico yesterday, which I highly commend to all of you, the 4 billion euro that I mentioned, which was generated by Euroclear last year, this is something like 10 times the net income of Euroclear in 2021. So this is quite a sizable amount of income for Euroclear. But normally these assets would not reside there. It's sort of an unusual situation. And as a matter of Belgian law, this is Euroclear's private property that the Belgian government has been taxing since 2022. But if that's the case, then you don't have any of these complex international legal questions of sovereign immunity or inviolability of these assets, or if you can invoke countermeasures or collective self-defense. None of these issues really pertain because this is private property. And so then the only question really is, can you tax this private property, this capital gains, these investment incomes? The question is obviously, the answer is obviously yes. Belgium can tax it at 25%, as it has been. It could also tax it, as I understand, I'm not a tax lawyer, but as I understand, under EU jurisprudence, it could tax it at 90, 95%. Apparently, you cannot go all the way to 100% because that's outright expropriation, but you can go close enough, 95% of the investment income. And that is a policy discretion of the Belgian government and of the EU. And that is really where the crux of the debate, the real debate, is right now. And the answer is, it's a discretion for the EU to request the Belgian government to indeed impose a windfall tax of 90 to 95%, whatever is, clearly consistent within EU jurisprudence, and obviously transfer those funds to Ukraine and Ukrainian claimants, because morally, there's no basis to keep those funds at Euroclear or in Belgium, right? These are sort of funds which have been generated by the sheer fact that there's a full-on war of aggression waged by Russia in Ukraine, and these assets have been trapped in Euroclear as a result of sanctions imposed by the EU. One sort of interesting legal theory that was offered by at least some EU officials is that maybe these profits don't actually belong to Euroclear. It's not a matter of national law, but they belong to EU itself, based on this fruit of the tree doctrine. And the argument there is the tree is the EU sanctions regime that was set up in response to Russia's aggression. And because of that, the assets have been trapped in Euroclear. And because of that, this investment income has been generated. And so the fruit of the tree, that is the EU sanctions regime, should belong to the EU. But not to keep it in the EU. I think morally everyone sort of recognizes that this really should go to pay for damage that Russia has inflicted in Ukraine. So you've been probably seeing in the news recently that just this past Monday, the EU foreign ministers decided to take the first step of what is supposed to be a two-step process, whereby they have decided to immobilize the profits, to set aside these profits so they're not, distributable to Euroclear's shareholders or recognized sort of as proper profit of Euroclear, but they're sort of set aside. And then the second step will be to actually impose the windfall tax on these profits, and then transfer those funds to the EU budget, and then transfer it to Ukraine and Ukrainian claimants. So that is just a little footnote on what has been really dominating a lot of political capital and attention in Brussels. And it's a little bit of a red herring because, all the complex legal issues that Anton has been discussing, again, are not triggered by any of these issues because the view in Brussels is that this is either private property, which is taxable, or EU property, which is transferable. Either way, it does not reverberate to the central bank of Russia. Sort of an open question why it's taken so long to go through this two-step process if all these underlying issues are relatively open and shut case, but that's where that debate stands. Now, of course, 4 billion is a lot of money, to be sure, but as you probably have also seen press reports and estimates by the World Bank and the European Commission and other institutions, the damage that Russia has inflicted in Ukraine already by early last year, March of last year, was already around 400 billion euro, 390 billion euro to be exact. And now another year into the conflict, into the war, those estimates are much, much higher. And so even if you collect 4 billion once a year, which is not bad, you're gonna have to do it for the next 100 years to be able to, or 150 years to be able to pay for the damage inflicted in Ukraine. And so that's not, even though it's a good step, it doesn't get you very, very far. And so then the real question is, what can you do with the underlying state assets? And there, the debate, to be honest, has been sort of muddling along in Brussels. It hasn't gotten very far over the past 16 months beyond sort of the pros and cons that Anton has laid out, except for maybe the past 3 months or so. I'll lay out where there's been the most immediate movement. So in the European Parliament, interestingly, the European Parliament doesn't have kind of the primary role in debating these issues. A lot of the work has taken place within the European Commission and in the European External Action Service, so the foreign ministry equivalent of the EU. But in the European Parliament, you've had a number of engaged members of the European Parliament, including the author of the op-ed I mentioned in Politico from yesterday, Włodzimierz Cimoszewicz, who was former Polish Prime Minister, former Polish Foreign Minister, incidentally also a former lecturer of international law at the University of Warsaw. And so, he understands obviously the legislative and the policy aspects, but can also speak with confidence to the international legal aspects. And he introduced an amendment to the parliamentary version of the regulation establishing this Ukraine facility, which is a budgetary top-up that's being negotiated by EU member states to provide something on the order of 50 billion euro of additional funds for Ukraine. And then this regulation, which would establish the fund that member states would contribute to, and then that would distribute funds to Ukraine. Cimoszewicz introduced a very sort of crisp and clear recital, which is that which called for confiscation of Russia's state assets, and noted that these are justified both under collective countermeasures and collective self-defense. Interestingly, the European Parliament itself, already in March of 2022, so just a couple of weeks after the outbreak of the full-scale invasion, invoked the clause of collective self-defense and the right of collective self-defense under the UN Charter Article 51, to call on EU member states to provide all the military support that Ukraine needs to prevail and to be able to defend itself. And the rationale of extending collective self-defense to then these issues of seizing Russia's state assets is with a similar logic to what Anton laid out, which is that, look, if the EU can train Ukrainian soldiers to send to the Ukrainian battlefield, as it does, it's trained tens of thousands now, soldiers that have gone to the battlefield, front lines. If it equipped Ukrainian soldiers, men and women, with weapons to shoot at Russian soldiers and Russian weapons and Russian assets, it can use, if EU member states can share intelligence to identify, where those assets and where those soldiers, where those troop lines are located. It can also, the EU member states can also engage in non-military, lethal measures, including economic measures such as confiscation of state assets. Now, and that's the view that's emerged in the European Parliament, both in support of collective countermeasures and in support of collective self-defense. It's probably fair to say that, as Anton laid out, in the External Action Service and the Commission, I take it in the US government on the basis of this reporting in the media, in the UK as well, people have sort of gravitated more towards the view of collective countermeasures, although there are some nuances in terms of exactly how to approach that justification. But at the very least, in the Parliament as well, you have support for the view of seizing Russia's state assets on the basis of collective self-defense. Now, in the Council itself, you have a group of states that have embraced over time the view that I think Anton in the end recommends, which is that these are difficult questions, no clear-cut sort of recipe book answers to them, but on balance, even if you have if you have adopted a favorable view to Russia with respect to sovereign immunity, and you have a broad view of sovereign immunity, which applies not only to judicial action, but also to executive action, right? So you have a conservative take and a kind of a defendant-friendly, as it were here, take of sovereign immunity. Then you still have strong basis in third-party countermeasures to be able to confiscate Russia's state assets. And that's probably fair to say that that's a view where a predominant number of EU member states are gravitating around. Now, there hasn't been a council decision to that effect yet. Like I said, a lot of the discussion and political capital and attention has been hijacked a little bit or deflected by this focus on the profits of the assets, even though the legal issues and the political issues are a little bit separate. But in any event, on the underlying state assets issue, people are gravitating around collective countermeasures. Now, for those member states which haven't been fully persuaded of this view yet, they probably would offer, it's interesting because you sometimes engage in these kind of candid discussions, and sometimes you have a very sort of honest exchange of views, but a lot of times it's not like in academia where you put forth one argument and you expect a reasoned counter argument, and then you can engage in a rebuttal, and there's a real kind of meeting of the minds and a real sort of exchange. A lot of times, it's a pretty blocking position. You present a series of arguments, and then you just get we haven't looked at this fully yet. we're not persuaded, but without full rebuttal, full counter arguments. But I think for those states which haven't been come around fully to the countermeasures doctrine yet, there are probably a number of sort of reflections in the back of their mind. And one is, what is this, if we take this step, what does it do to any potential disputes that may have occurred on the basis of prior conflicts? And that is sort of a conflation of two completely different things, because, countermeasures is something that applies in the here and now and prospectively. There's an ongoing war. There's an ongoing war. I'll wrap up in 3 minutes as our organizers kindly flagged for us. There's an ongoing war now, and countermeasures is supposed to allow you to suspend your ongoing obligations towards the aggressor as a way of inducing that aggressor to get out of the country that is invaded and to pay reparations. Countermeasures does not allow you to say, well, what about that war 100 years ago, 200 years ago? Let's revisit that issue, and maybe we suspend our obligations towards you until we resolve our, issues with you over 200 years ago or 500 years ago, whatever you want to do. It doesn't apply that way. And then, prospectively, does this open up the Pandora's box? And, everyone says, where does this end? It's the slippery slope that will lead you to nowhere. And the truth is that these are very limited circumstances. Even in today's very violent world, countries do not wage wars of aggression seeking to change borders and to completely acquire other countries, luckily. And we don't want to get into that world, right? That's the whole point, that we're trying to preserve some basic rules of international order, which is that borders are supposed to be inviolable. You cannot change them by force. This is something that everyone has an interest in. And so that's why we can do this in these very, very limited circumstances. This does not open up, lots of other circumstances where other countries can engage in this. You've had a series of UN resolutions clearly condemning Russia for its conduct, clearly recognizing that Russia has to pay for the damage it's caused. And so, if hopefully this will never happen again, but if there's another war of aggression of this type, then yes, we should apply the same logic, the same principles, and the aggressor's assets would be confiscated or would be subject to confiscation. And I would not want to set the other precedent, which is that, for wars of aggression, don't worry, you can wage them safely because your assets are still going to be protected from confiscation. So, go ahead and destroy other countries and inflict damage. You'll be fine in terms of your central bank reserves that we're holding in our capitals. We'll get to other issues, but I thought include the economic and political considerations, but I thought it would be worthwhile to just spend a little bit of time on these legal complexities.
Great. Thank you very much to both of you. Anton, first for giving us a broad, comprehensive overview of the complexity of the legal arguments and a balanced overview as well, giving different assessments of the legal complexity. And then Bart for giving us really an update on how things are playing out in Brussels and how we go from the abstract to the applied in the current moment. I'm going to open it up for questions. Let me just say, prior to this session is being recorded. So this is on the record. For those of you concerned about being on or off the record, you may or may not be, just so you know in advance, this is being recorded. So frame your questions accordingly. We also have a very distinguished group. A lot of names I recognize on the participants who are not here with us in the room. So I'm looking for raised hands there, but I'll be watching. I've got the screen over here. I can do that. And there's one hand. Sorry.
Do you mind if I just add, I just had an idea if there's anybody, because I see there's a few governments online as well. If anyone wants to raise a question that isn't linked to themselves, you could type it in the chat to Sylvia, who's hosting the online room.
Thanks.
And maybe Sylvia would kindly read it out in an anonymized fashion, and then we can still discuss some of the topics if those who don't want to be linked to the questions themselves.
And if I see one hand already from here too now, if I could just take, I'll abuse the prerogative of the chair and make just a couple of observations at the outset. Perhaps that'll trigger some other thoughts, and then we'll go to the two questions we've already seen and we're watching online as well. First is and Anton knows probably where I'm going because we've already had this conversation in several locations, but I guess that when I listen to this, it's the broad question that I think about is not is it legal, but is it good policy? Is this really the right policy to confiscate the assets at this point? And I have no qualms about the moral case. There's no question in terms of the moral case, but I have a slightly different take on this. That's obviously because I'm not approaching it as an international lawyer, but as someone who works in international relations and foreign policy analysis. Just two footnote points, and I'll come to elaborate on those 3 points. First, one on to Bart's presentation on the $4 billion. I happen to have been around when targeted financial sanctions were first being developed 25 years ago. And the logic of the conversation here at Interlaken in Switzerland in 1999, so it's literally 25 years ago, was that you wouldn't confiscate interest being earned. The banks, there's a real question of, well, what happens if you freeze the accounts? What if do we add interest to them? Do we make them more valuable to these individuals or entities that are being sanctioned? And the logic was, no, you would allow the interest to accrue to provide a greater incentive for the targets to comply. So there's a bargaining logic built in at the outset, and that was the way people thought about the design of targeted financial sanctions. You would actually make the assets more valuable over time. And I'll come back to the bargaining point in a moment. Anton, on your presentation, I think it's interesting to think about, particularly in the legal arguments, that some of the cases and some of the references are back to decisions taken in times of formal declared war, and others are not. And I think it's important to, at least again, from the political science international relations standpoint, to keep those two types of cases separate, because what you do in war is not the same as you do in peacetime with regard to the application of restrictive measures for political purposes, which is how I define sanctions. And I think we need to get beyond the confusion, the conflation that Nick Mulder has provided to many of us in his first chapter, where he keeps going back and forth between warfare and sanctions as if they're the same thing, and they're really not historically. It's a disciplinary perspective. I like being corrected by my law students to say, don't talk about sanctions, talk about restrictive measures. And I've joined you on that one, so that's my new language. Now, my point about is it legal or is it good policy? It goes on 3 points, and I just want to put these on the table. It might be legal, but first, it does involve interfering with pretty well widely shared norms about how the international financial system operates in terms of the system of reserves. And the one big question, one should at least think through, game through, involve some kind of scenario planning before acting on confiscation to think through what might be implications of this precedent for the future stability of the international financial system. So that's one question. Worth, I know Anton has written a piece, which I read this morning, about this. I'm not fully persuaded, but I know where you're going with this. My biggest point is, goes back to the point about allowing assets to increase in value, because my current research is focused on how you utilize sanctions relief to facilitate negotiated settlements in conflicts. And so if you confiscate the assets, you're taking 350, maybe, not like just the state assets, you're taking 350 billion off the table. Might that at some point be useful in a bargaining negotiation session? Because once you confiscate it, well, there's no, in fact, we see when the UN increases its sanctions substantially, targets often have nothing left to lose and actually increase their prescribability. So think about the second. And the third is reparations. And this is a longer story. I believe now British policy is in favor of reparations post-war. So we're getting there. But you mentioned how long it would take to pay off at $4 billion a year. So keep in mind, Germany paid reparations until this century for World War I. So we're actually talking about mortgaging up at least a century forward, if not further. So think about that. And the last time reparations were applied after a major war, it didn't necessarily lead to good outcome longer term historically. But I don't want to overstate the German case. But just a couple of comments. You don't have to respond now. Think about it. Let's take the other questions from the table. And
I think, is it
Anyone
possible that
online?
people have their hands up and we can't see it? Because I have only one hand up and that's Ivan.
Yeah, okay.
okay, there is one hand up. Okay, but let's take the two in the room and
You
then.
already addressed my question, so.
Okay.
Yeah, thanks for brilliant presentations. It
Please
was-
introduce yourself and.
Okay, Bogdan Bernatsky, kindly invited by Aurelian, Max Weber Fellow at EY. Thanks a lot for your brilliant presentations, and I just want to raise one more critical variable which not covered, but I think that it is crucially important to at least give attention to this variable. Variable in what form the compensation will happen. In form of 27, for instance, unilateral decisions across Europe, so governments adopt their own decisions on compensation, or in the form of international legal treaty. And what we know, like from the very, very basics of international theory, is that international treaty, which come in force, it creates new norms. And could we compete these norms to norms which were described by Anton in his presentation? And would these norms in new international treaty create new legal norms, which we would then like discuss and debate? And to challenge international treaty, it's much more harder than to challenge unilateral decision taken by individual government. And it's kindly interesting if like we have such international treaty concluded by European Union, United States, United Kingdom, Japan, South Korea, and a few other countries which joined sanctions against Russia, and to which different legal consequences it will lead us. I think it's very important. And the second level question which comes from this one is, do we consider European Union to adopt such decision on confiscation? In what form? In form of council decision, or again in form of unilateral decisions throughout all 27 member states? And again, it will lead up to these different consequences because if it is a decision of the council, then it will be challenged before a European Court of Justice. But could like Russia bring a claim to European Court of Justice is an open question. And secondly, how will it affect it again the compensation infrastructure at all? And one very, very last point is the issue which is critical need to be addressed is the proportionality of international measures. Because what we now observe is that Russia confiscating different entities belonging to unfriendly states, and these measures are done unilaterally. And do we preclude or do we understand from international law that other states could take countermeasures in response to the confiscation of their companies on the territory of Russian Federation? So they change agenda, saying that you confiscated a number of our companies in your country and we do the same measures in response to these measures. So yeah, it's just open-ended questions, but thanks a lot. And I would like to know if you know some discussions inside the Brussels, whether the forum is, now debating.
Thanks very much. Ozan, you didn't want to add anything? Okay. Should we take the question online?
I have a written question and then I have two persons who want to raise hands, sorry. So maybe the first written question. So building on a point made by the colleague in the room regarding...
Who this is, sorry, so we know who's posing the question.
Felipe Morgado.
Thank you.
Building on a point made by the colleague in the room regarding the potential impact of asset seizing on the global norm in the financial system, are there legal or political perspective in this topic for non-Western countries and experts? For instance, is there any sense of what the potential Chinese reaction would be? And then I have Yvonne still and Nathaniel waiting to be here. They're online.
They're online, but no one will take those as well. Yeah.
All right, then maybe first, Yvonne, you can take you can put your mic on and then speak up.
Sure. Thank you very much, Anton Moiseienko, for organizing this meeting, and the presenters, really, Anton in particular. Your insights really are being so welcome and incredibly useful. I have 3 specific questions, if there's time for that. The first one is, you have different readings about how quick or not very quick the G7 countries are being in moving from debate to policy making. And as you rightly noted out, we have the Senate Committee of Foreign Affairs passing the bill that would obviously give the green light for the confiscation of Russian sovereign assets, that being approved. Some homework that apparently was being put forward for G7 countries for their February meeting. Canada that passes this legislation, as we know, on confiscation of assets. So all of that points to they are moving rather quickly from debate to policy making. But on the other side, you have the Europeans, which appear to be more cautious. My question is, what is your assessment? Are we seeing a quick move under international law in from freezing to confiscation of sovereign assets, or in reality, it's going to be difficult in the United States? The debate will continue to be entangled in the EU space, and so we're not really moving that fast. Is it fast or not? That's the first question. The second question is, I wonder, in terms of your expertise, if you might be able to maybe give some light on the following. I read an article recently which spoke about the sovereign immunities in the context of confiscation of assets. And what the article said is that exceptions for state immunity involve genocide, crimes against humanity, and war crimes. But under international customary law, even central bank foreign reserves are strictly off limits. So are there exceptions for confiscation of assets when you have crimes against humanity, war crimes, et cetera, et cetera? That wasn't mentioned in your presentation, but something I read. So that would be useful as a matter of clarification. Lastly, if you have any insights on Canada, I mean, their law appears to be applicable to confiscation of assets when there is international conflict. What do we mean by that? Is international conflict in which Canada is part of? Or any views on that will be greatly, greatly welcome. Thank you. Over.
Thanks very much.
Nathaniel, do you want to put your question forth now?
Thank you very much. Sorry, I'm not able to turn my video on. I hope you can hear me clearly.
Yes.
Yeah, thank you both presenters. That was a really excellent and very enlightening discussion. I really loved Anton's your presentation, part of your reflection as well. I've got a point where I think I invite both of you, but particularly maybe Bart to reflect because it's got a policy angle to it. I'm thinking about the proposition that financial confiscation is reversible. So that idea assumes that money could be returned in kind anyway. So the problem would be when that money would not be able to be returned, or the states simply refuse to return, and the idea or the guarantee is that, well, you can do the same to the other states. You can basically just attach or seize their money as well. So the question is, in a world where sovereign assets only have unidirectional travel, they only travel from peripheries to world financial metropoles, and not the other way around. So in this, and this is somehow different in the case of private funds, which kind of circle around the world in multiple directions. But in terms of sovereign funds, they really only travel in one direction. So in this world, the idea that financial confiscation is reversible seems really patently theoretical. So my idea is, my question is to invite you to think, is there anything that the Western governments that can do to reassure the rest of the world to kind of come on board? Can we perhaps bring this discussion to more multilateral discussions, forums such as the IMF or elsewhere, where some type of reassurance or consensus could be built instead of the going it alone approach, where we know, the law is right on paper. In reality, the law only works in one particular scenario because there is only one party that has the power to actually attach sovereign funds, because all the rest of the world does not have possession of US sovereign funds in their national banks, etc. Thank you very much.
All right. Thank you. I think that's quite a list to begin with, and we'll see if we have any further questions from around the table after you get a few moments to respond. Pick and choose as you wish.
Sorry, I'm just trying to plug my laptop in. Please ignore me.
I don't know.
Great. Yeah, no. Maybe I could just jump in on some of the economic and political arguments that were raised, and because I was going to get into them in the presentation as well. So on the question of whether you should let the value of the assets continue to inflate and accumulate interest and so forth, that consideration might make sense for the purposes of immobilized private assets, where, at a certain point, you'll have the individual in court, or as part of the overall negotiation or process with an individual and resolution of that of the issues with the individual, you want to maintain a larger carrot as an incentive for that individual to come into compliance with whatever laws he or she had violated. In terms of the Russian government and negotiations at some point in the future and reparations and so forth, this is a very right now far off scenario, and it is an open question, to be sure, whether you can use the immobilized assets as leverage when the time for peace negotiations will occur. But the truth is that the damage that Russia has already inflicted in Ukraine goes so way beyond the volume of the central bank assets, is that there'll be plenty of negotiating still to do, because even if the 300 billion are confiscated right now, or 304 billion with the profits, Russia will still be on the hook for, I don't know, 200, 300 billion, by way of remaining reparations, potentially more. President Zelensky has estimated the reconstruction might cost something like €1 trillion at some point. In any event, so that remaining bill can be very well part of the negotiations whenever they occur. The other rationale for seizing the assets now, rather than waiting off into some distant point in time, is that, and this is not my idea, but one offered by Larry Summers at some point last year, is that, if, let's say, you imagine we are able to finally have peace negotiations with a Russian government, in that scenario, I don't know if it's a year from now, 2 years from now, longer, Minister Sikorski, for instance, the Polish foreign minister, estimates this might take 10 years, who knows? Modern conflicts can last a long time. But whatever that is, that government presumably will be a little bit more pro-peace, a little bit more pro-Ukraine, a little bit more pro-West than the current regime, right? A lot of times these things are concluded by a team which is different from the team that started. And so the question is, do you want to, at that point, say, by the way, we've got 300 billion or 300 billion plus of central bank assets that we're going to confiscate in 2026, 2030 to be able to pay for all the damage that you caused, when you have a slightly a better partner to negotiate with? Do you want to kind of squeeze them at that point? Not only by seizing their assets, but also having them pay for all the rest of the damage that they've caused? Or do you want to exert that economic pressure now, and you want to squeeze their military machine now, squeeze their economy so they cannot fund the weapons and the bullets and all the soldiers that they're funneling to the front lines? To be sure, it's a judgment call, but I think my judgment on that is you want to do it now. You want to do it as part of the economic pressure campaign against Russia, which is targeted against the military machine, and you don't want to wait until some distant point in time as part of peace negotiations. Maybe let me just touch on one point on the international financial order, which I think is another counter argument that's popped up late last summer from the European Central Bank and other institutions, And it's a potentially legitimate concern. But other than floating the concern, I have not seen any sort of scenarios, Monte Carlo scenarios, or any other gamed out estimates of what are the economic risks that are calculable. And the arguments that I've seen is that, in a nutshell, where are all these assets going to go? Most of the central bank reserves are in Western capitals, 90% plus, in London, Frankfurt, Tokyo, New York, Paris, so forth. And for good reasons, because governments want to fund their international financial transactions, China, South Africa, Brazil, lots of governments. And sure, they can move it somewhere else, but the truth is that there's nowhere else to go right now. So they would have to really recreate the financial system from scratch. And, that has its own costs and risks and so forth. And so, my sense is this money is probably likely to stay where it is right now. Because, already you have the clear signal by Western capitals that they're going to immobilize these funds if you wage aggressive war. And so some of the political risk or the financial risk is already baked in, and the allocation has not moved all that much across the world, apart from Russia trying to distribute its assets. And then the other point is, let's say a country decides to pull out its funds out of Western capitals, as Russia tried to do. What signal does that send? Are you trying to wage aggressive war and prepare for that in a year's time or 2 years' time? And so you want to, limit the exposure that you have. Probably not a good signal to send to the rest of the world, not only politically, but also economically. And so unless someone, comes in and says, the sky is going to fall and we have clear financial estimates to back that up, I think right now this argument is a little bit over exaggerated. But to be sure, these are all legitimate policy, economic considerations that policymakers should engage in. I think the main message from us is that the legal issues are pretty clear, and you're on sound grounds, just to wrap up with your question, to go ahead and do it. And Belgium could do it on its own on the basis of these international legal arguments that we've laid out, because Belgium is a third-party state that's especially affected, that can come to the aid in the shoes of Ukraine, to the aid of Ukraine, either on the basis of third-party countermeasures or collective self-defense, and seize these assets on its own. It, for political reasons and legal clarity reasons, wants to move alongside the EU, the Council of the EU, not necessarily a treaty, but the Council of the EU, as well as with the G7, to make sure that all the Western capitals are aligned to forestall any economic disruptions that might potentially arise if you have one part of the system moving rather than the other.
It's such an excellent and powerful point, to end the event on, that I almost sort of feel bad. I'm in violent agreement with all of that, and sort of that concluding message as well. Just a couple of quick things to reflect on what I think were the themes that underpin some of the questions. In terms of the precedent that is being set now, I think there is a real question there of how do we frame the expectations as to when sovereign assets might be frozen and then seized in response to aggression. So what is the scale of the wrongdoing that would justify such a measure? Is that any unlawful use of force? Probably no. Some sort of an interstate war of aggression? Probably yes. The Russia-Ukraine situation is easy in that sense because so many things have happened. The war of aggression, war crimes, acting in defiance of the conditional measures ordered by the International Court of Justice, and so on. But I think the real question is, how does one frame in political terms the parameters of that new practice? And what is the signal that is being sent to the rest of the world as to how the international community will respond to such actions? And I think this is where, the contours of, say, an international treaty or a joint course of action by all the G7 countries plus others who have frozen Russian assets would be monumentally important. Now, in terms of some of the questions that arise in the Russia-Ukraine context specifically, I feel like a lot of those questions are dramatically influenced by the fact that we are talking about immense amounts in reparations, as Bart mentioned. So I think that a lot of the bargaining logic kind of breaks down. It's almost like, this sort of black hole that dwarfs light around it. And, a lot of the concerns we would otherwise have, they kind of are warped by the, massive amount of reparations. So yes, you could use frozen assets as a bargaining chip. But if you want to use them as a bargaining chip to get Russia to pay reparations, you can't do that because Russia owes more than that in reparations. If you want to use it as a bargaining chip for something else, for example, the simple cessation of hostilities, sure, that works. Presumably, maybe, it could be one of the factors. But what I find somewhat difficult about the bargaining chip arguments is that I think very often they kind of don't fully articulate the logic. And if the logic is, let's forgo the demand for reparations for now, just focus on the cessation of hostilities and retain frozen assets as a kind of bargaining chip to incentivize Russia to cease hostilities, I think that's intellectually coherent. It strikes me as potentially moral and politically unappealing. But I think, that logic has got to be carried throughout the analysis. And another issue in this context that kind of warps the discussion that we would otherwise have is in the context of Nathaniel's question about the reversibility. The issue of reversibility would only arise here when Russia complies with its obligations. So that means Russia paying reparations to Ukraine. Well, those reparations would be higher than the SS frozen to begin with. So once again, the sort of very reasonable question we would otherwise have simply breaks down because of the amounts involved and the kind of practicalities of this situation that we currently have. And then there was a question around the reaction of non-Western countries to this situation. It's interesting because I haven't seen any sort of strong opinions issued by most of the world either way. Most of the world seems to be reasonably not publicly opposed to the freezing of the Russian central bank assets. What do they think about potential confiscation? Unclear. I think that if we look at Russia and China, those guys, those countries are on a trajectory to try and extricate themselves from the global financial infrastructure or the Western financial infrastructure anyway. So, we're not calling them to that audience, anyway. They're pretty set in terms of what they think is the right thing for their countries to do. What the rest of the world thinks, I think, is going to be dramatically influenced by that precedent that is currently being set. Are we very clear in terms of how we're going to use those freezing and seizing options in the future? And the credibility of that, I think, is absolutely essential.
Just have one last comment from Marusha, who's asking if we can share the papers after this meeting. Yeah. And I already have Anton's paper, but maybe Bart, if you could share something as well.
Sure.
Yeah,
this
we'll
is
do that.
Marusha Weber from Slovenia. Good. Nice to see you, Marusha. Or here,
yeah.
To see you present. Any other comments closing? Okay, I have to catch a call at 4. I apologize. Thanks to both of you. I'd like to follow up more. I have some further comments and reflections. Maybe we can do it a little bit later in the afternoon. But
okay, I'll take
this question and then you'll close.
Thank you, Tom.
Okay,
we will try and wrap up as soon as possible because I know some people have got things to go off to. But for those who do want to stick around, we can hear the final question. And just to say, we're also in the process of planning a much bigger event on this topic with Anton, hopefully with Bart as well, and a series of other speakers covering the different political, legal and other angles. So please watch this space as well. So you need to rush off. So thank you once again, and please, if you can keep the question relatively brief, it would be
Thank
great.
you for both presentation. It was so really educational.
Introduce yourself.
I'm sorry. I'm Fariba Al-Karami, a postdoc fellow at here, and with the Professor Bielsteker works on the sanction, especially about the bargaining and punitive sanction. As Anton mentioned, the confiscation is irreversible. I remember the case of Afghanistan, the frozen assets of Afghanistan by United States. And as probably we know, one debate was mentioned at there, the frozen assets of Afghanistan not belong to Taliban, it's belong to the people of Afghanistan. And now I'm interested in know whether this same idea may be raised at this case of the Russia. For example, it may be the, especially I want to know who is responsible of waging of war, Putin state or all of country of Russia. And in that way, we consider the the seizing of the frozen Russia central bank assets is belong to the all of country of Russia or not. We can consider just a state of Putin. And the final question is that if we consider this action like countermeasure, it's against what of the violation of Russia, waging of war or no? Have a debate to reparation the Ukraine. Thank you very much.
Yeah, thank you. Maybe I can have a quick go at that. I think it's an excellent kind of philosophical question of, whose money is it? I think that at the end of the day, one is inevitably reduced to a certain sense of formalism in the sense that, there's Russia as a state, and there are a number of things that we're doing, to that state to limit its ability to wage the war in Ukraine. Sadly, at some point, it might mean some trickle-down effect on the financial well-being of ordinary Russians who don't have, anything to do with Putin's decision-making. We've had those dilemmas in an even starker manner with places like North Korea. Russia is nowhere near, that sort of level of humanitarian consequences. But I think, in principle, we do have that question in any sanctions regime. How can we try and influence the country without trying to influence everyone who makes up that country? An obvious kind of impossible paradox. And then when we try to look at that in the context of the seizure of the assets, it would be nice to I'm trying to find the right words here. It's a shame to take away the property that could be used by, a modern democratic Russia to rebuild itself. But I think in practical terms, the real choice there is someone's got to pay for the rebuilding of devastated Ukraine, the reconstruction of Mariupol, and so on. And there are only a couple of options. The people of Ukraine who currently have no money, the taxpayers of the European Union and other allied nations who are helping already, and then the pot of money that has been accumulated by currently Putin's state. And I think the kind of policy choice there kind of answers itself, really.
You want to add a few final comments?
I very much agree with that. And I would just maybe add one overarching comment, which sort of echoes some of the sentiments that you voiced, which is that, there are two ways to proceed within the international legal system here. One is the way we've outlined, which is an interpretation of international law, which is actually in the defense of an invaded state, in the defense of the victim. And that applies not only for Ukraine in this instance, but for any state that is harmed by another state. So the logic of collective countermeasures is basically, we can come to your aid by pressuring the aggressor state and suspending our legal obligations towards that aggressor state to come to your help. So it's basically an interpretation, an application of international law that is promoting and friendly towards weaker states in the system. The other option, the other interpretation is a very absolutist view of sovereign immunity and the inviolability of assets of aggressor states. And then the view is basically you're off to fend for yourself. So Ukraine, you can go on and keep fighting and defend yourself, but forget about collective countermeasures, forget about others coming to your aid, unless, we want to join the fight on the front lines as well. But any measures short of that are off the table. And I think, this is not just a policy preference that we have, but there are very, very strong legal arguments to choose the first path rather than the second path. And longer term, it will create a much better, much more humane international legal system, which I think goes to some of the underlying points that you voiced.
Thank you very much. Well, I think in the interest of Swiss punctuality, we should conclude here. And but anyone who wants to hang around and chat, please feel free to do so. I'm not sure we've actually set the next session. So if any of you want to volunteer and talk about a paper or something that you would like to brainstorm regarding sanctions, please get in touch with us and we can start setting that up maybe for next month. We're aiming to meet once a month as well. So for those of you online as well, feel free to keep watching what we're doing and join us next time. But thank you very much to Anton and Bart. We really appreciate you coming over and sharing such insightful presentations with everybody. I think everyone will agree it was incredibly useful and insightful, and thank you once again. Yeah.
Just to let you know as well, for those in the room and online, the next meeting session is scheduled for the 23rd of February from 12 to 2. And we've already booked this room, so you can.
But we don't have the speaker yet, right? Okay, good. So yeah, hopefully somebody will volunteer. Thank you.
Great. Thanks
Thanks,
very
Phil.
much. Thank you for your questions.